Imagine this. A construction crew shows up next door. They start digging, but they are not on your neighbor's property. They are on your land. Or picture this. A magazine is about to publish a story about you, a story filled with lies, damaging lies. In moments like these, waiting for a lawsuit to finish can feel like an eternity. The damage will already be done. The foundation will be poured. Your reputation will be in tatters. Money, awarded months or years later, can't always undo the harm. This is where a powerful legal tool comes into play. It's called an injunction. An injunction is a direct order from a court. It's a command. It tells someone to stop doing something, or in some cases to do something specific. Think of it as a legal stop sign. It's a way for the justice system to step in quickly, to press pause on a situation that is causing immediate and potentially irreversible damage. It's not about deciding who is ultimately right or wrong in the long run. Not at first, anyway. It is about preventing a catastrophe. It's about preserving the status quo, keeping things as they are until the courts can sort through all the facts and make a final, considered judgment. The stakes are often incredibly high. It could be your home, it could be your business, it could be your very name on the line. An injunction recognizes that sometimes justice delayed is truly justice denied. So why does this matter so much? Because some wounds can't be healed with a check. Consider a developer who plans to demolish a historic landmark in your town. Once that building is gone, it is gone forever. No amount of money can bring it back. Or think about a company that is about to leak your private, sensitive data online. The violation of your privacy is immediate and widespread. An injunction is the mechanism designed for these urgent scenarios. It is the legal system's emergency brake. It provides a shield when you are most vulnerable, offering protection not after the damage is done, but before it can even happen, or before it gets any worse. The core idea is simple: protection. Protection of rights. Protection of property. Protection of peace of mind. When someone's actions threaten to cross a line from which there is no easy return, an injunction can be the only effective defense. It's a declaration that some things are too important to be broken first and paid for later. It's a tool that empowers individuals to stand up and say, "This isn't right, and it needs to stop now." Understanding how this works is crucial, because it's a right that can make all the difference when you are facing a situation that feels unstoppable, giving you a voice and a fighting chance when time is running out. Courts have a whole toolkit of injunctions. They are not one-size-fits-all. Each type is designed for a specific kind of problem. Different level of urgency, different goal. The most common type is a prohibitory injunction. It prohibits someone from doing something. A court order that says, "Do not do this." Imagine a neighbor playing loud, blaring music all night. A court could order them to stop. It can also stop a company from infringing a patent, or prevent someone from harassing you. It's about drawing a clear, legally binding line. Then there's the flip side, the mandatory injunction. More forceful. It doesn't just stop an action, it commands one. It tells someone they must do a specific thing. Imagine a landowner builds a fence blocking a public right-of-way to a beach. A court could order the fence torn down. Courts are generally more cautious about granting them, reserved where stopping isn't enough to fix an existing problem. We also have to look at timing. Temporary injunctions or interlocutory injunctions are short-term solutions. A judge grants one to freeze a situation and maintain the status quo while the case is ongoing. Two business partners fight over control of a company. A court might prevent either partner from selling off company assets. It's a legal timeout, so the subject of the fight still exists when a winner is declared. Finally, the permanent injunction, the end of the road, issued only after a full trial on the merits. If one party has been consistently violating the other's rights, it can be made permanent. A court could forbid them from ever doing it again. So, how does a judge decide whether to grant an injunction? It's not automatic. They don't hand them out just for the asking. Courts perform a careful balancing act, weighing several key factors before issuing such a powerful order. The first thing they look at is the likelihood of success. The person asking for the injunction has to show the court that they have a reasonably strong case. They need to present enough evidence to convince the judge that they will probably win when the full trial eventually happens. They don't have to prove their case completely at this early stage, but they can't just walk in with a weak or frivolous claim. The next, and perhaps most critical factor, is something called irreparable harm. This is the heart of the matter. The person seeking the injunction must prove that they will suffer a type of harm that money simply cannot fix. If the damage can be easily calculated and compensated with a financial payment later, a court will likely deny the injunction. But if the harm is irreversible, like the cutting down of ancient trees, the loss of a unique business opportunity, or the destruction of one's reputation, then the argument for an injunction becomes much stronger. Then comes the balance of hardships. The judge essentially puts the potential harm to both parties on a scale. They ask, who will suffer more? They weigh the harm the person asking for the injunction will suffer if the order is not granted against the harm the other party will suffer if the order is granted. For example, if a factory is polluting a town's only water source, the harm to the town's residents from continued pollution is likely far greater than the financial harm the factory would suffer from having to temporarily shut down or install filters. The court will try to find the path that causes the least amount of overall damage to everyone involved. Finally, the court considers the public interest. An injunction is not just a private matter between two parties. It can sometimes affect the wider community. The judge will ask whether granting or denying the injunction would serve the public good. These legal ideas can seem abstract, so let's look at how they work in the real world. Here are 3 distinct situations where an injunction can be a lifeline. First, consider a classic neighborhood dispute. Let's say your neighbor decides to build a large extension on their house, but their plans show the new structure will be built directly on your property line, blocking all sunlight to your garden. You've spoken to them, but they refuse to stop. You can go to court and ask for a prohibitory injunction. You would argue that the loss of your property and the destruction of your garden constitute irreparable harm. A court could order construction to stop immediately, preserving your property until the boundary line can be officially determined. Now, think about a case of defamation. A blogger with a large following is about to publish an article falsely accusing you of committing a crime. Once that story is out, your reputation could be ruined instantly. Retractions and apologies rarely reach everyone who saw the original lie. This is a prime example of irreparable harm. You could seek an injunction to prevent the publication. The court would have to balance your right to protect your reputation against the blogger's right to free speech. Finally, imagine a fight over a piece of property. You have a contract to buy your dream house. But just before the closing date, you discover the seller has received a higher offer and is planning to sell it to someone else instead. This specific house, with its unique features and location, is not easily replaceable. Simply getting your deposit back doesn't make you whole. You could file for an injunction to prevent the sale of the property to anyone else. This action would freeze the transaction, holding the house in legal limbo until a court can rule on whether your original contract is valid and must be honored. It stops the seller from making the dispute irrelevant by selling the home out from under you. In each of these stories, the injunction serves as a critical shield. It stops a neighbor from taking your land, a writer from destroying your name, and a seller from breaking a promise on a one-of-a-kind property. It doesn't solve the entire problem on its own, but it buys crucial time, preventing the situation from spiraling out of control while the slow wheels of justice turn. So where does a court get this immense power to order people around? It doesn't just come out of thin air. This authority is firmly grounded in law, built up over centuries of legal tradition and codified in specific statutes. In many legal systems, including those based on English common law, the power to grant injunctions is an inherent part of a court's equitable jurisdiction. That's a fancy way of saying it's part of a court's fundamental duty to ensure fairness when the strict application of the law or monetary damages won't lead to a just result. It's about doing what is right and just, not just what is technically written in a contract. In many countries, this power is also spelled out in written laws. For example, in India, the rules governing injunctions are primarily found in a law called the Specific Relief Act of 1963. This act provides the framework that courts use when they decide whether to grant temporary or permanent injunctions. These laws provide a clear roadmap for both judges and citizens. However, having the law on the books is one thing. Applying it is another. A crucial aspect of the law of injunctions is judicial discretion. The law doesn't create a rigid formula. It doesn't say, if X and Y are true, you must grant an injunction. Instead, it gives judges significant discretion. This means the judge, in your specific case, will look at all the unique facts and circumstances and decide what is fair. It's a judgment call. This flexibility is the system's greatest strength, and at times, its greatest challenge. Two judges, looking at a similar set of facts, might come to different conclusions about whether to grant an injunction. One judge might place more weight on the potential harm to a business, while another might be more concerned about environmental damage. That is why the quality of the arguments and the evidence presented to the court is so critical. The law provides the tools. So, let's bring it all together. At its core, an injunction is a simple but profound legal concept. It is a court order that acts as a shield. It is used to stop someone from causing harm. It is used to compel someone to fix a wrong. We've seen that there are different types. Prohibitory orders that say, stop. Mandatory orders that say, do. They can be temporary, a quick fix while a case unfolds, or permanent, a final, lasting solution after a trial. They are not granted lightly. A judge must carefully weigh the facts, balancing the potential for irreparable harm against the rights and hardships of everyone involved. The power of an injunction lies in its immediacy. Legal battles can take years to resolve. An injunction provides a way to get protection now. An injunction is a powerful reminder that sometimes the only just solution is to stop the harm before it ever has a chance to happen.